Let me, first of all, thank you for taking this trouble of coming all the way to Mumbai. I greatly appreciate your commitment to this.
Thank you.
And your earnestness, seriousness in this endeavor, refreshing. I've become a bit cynical about these efforts because most of the time it's an emotional outburst against a system which couldn't have been mismanaged better. And the solution is not in the hands of lawyers or judges. It's too serious a problem to be left alone to lawyers and judges, administrators and government. It is a professionally oriented solution that has to be developed from virtually court to court. One size doesn't fit all. For instance, I'll tell you, there are about 30 million cases in the subordinate courts in India, roughly. 19 million are criminal cases. 11 million are civil cases. In the high courts, we have about 3.4 million, say 10% of the subordinate courts pendency arrears are reflected in the high court. But there is a dramatic reversal of the proportion of civil and criminal cases. In the high court, 80% are civil cases, only 20% are criminal cases. Second point I wish to emphasize is, out of this 30 million, over 50% are concentrated in 5 states. And
over how much?
50% are concentrated in 5 states in the country. The rest of the 22 states have the balance of 50% distributed. First thing necessary is to have a statistical breakup of dependency all over India and breakup of state-wise breakup. And within each state itself, there is not an even distribution amongst all the districts. Some districts have a concentration of this case. Now, if you want a systemic solution for it, it is absolutely necessary that computer systems men who are management men who can give you, of course, lawyers. Let me tell you, there are first-class judges in the various high courts who have experience with this, how to handle it. Now, the problem in this country is when you come with a solution, somebody says there's a better solution. The excellent is the enemy of the good. And they won't try out even what is good and what is helpful for the time being. First and foremost thing is that you must have a cutoff date, say 1st of January 2012. Cases filed on and after 1st January 2012 are processed on an assembly line. You start and you have a combination of a system of case flow management coupled with what they call the Six Sigma system.
Yeah.
For example, you say filing of a case, filing and registration of a case. How many physical actual steps that are involved in it? A man walking up to the counter, presenting his claim, the man receiving it, have a checklist, find out whether it's a limitation, court fee has been paid, all the check. With that time schedule within which it should be done.
And verification also.
Verification of this thing. And then on the day of presentation, what are the steps to be taken? What are the tick to be complied with? Then you issue notice. service time, if you take the history of any litigation, one says, the amount of time it takes in serving people of the side, in the initial stage, the first appeal stage, second appeal stage, somebody dies, the legal representatives have to be notified. That time is anywhere between 15 to 25% of the entire litigation time. Service is not that. Now, you have to have modern methods of communication. If he gives you that a man has a internet ID address, you must provide it, send it also. So that various methods have to be found for effective and speedy communication of process of court. Then there is a time schedule now given in the civil process code itself. What are the time schedule for each stage? So there is a stage, that is completion of the pleading. That should be done in accordance with the time prescribed in the civil procedure code. B stage is the case takes a loop line. The interlocutory applications run in the vertical direction. This loop line goes for mediation, conciliation, reducing the complexity of the case, and depending on the consent of parties, striking of issues, and filing of examination chief affidavits. This man is a retired judge or a senior lawyer who is a conciliator, a negotiator, arbitrator, or whatever, depending upon the thing. This loop line goes up. What he does is, he sends for the party, tells them the weakness of each person's case, the strength of his case. If they can settle the matter there, well and good. If it is not settled, it is reduced to speculative things are taken away. Supposing a man makes extraordinary claim, chop it off and
come to the bare facts.
Come to the bare controversy, the essential controversy. And if parties agree, he will also frame the issue. If the parties further agree, he will say this, so many witnesses are to be examined.